Items 10 through 17 are on consent. Madam Clerk, item 18, please.
Item 18, ad hoc report, property tax abatement.
Mr. Cobb?
Your Honor, at this time, if the council will indulge me, I'd like to make a motion to waive the reading of the report.
I'd like to
Okay, we have an objection. So, Mr. Cobb, you can do one of two things. You can withdraw your motion, we can read the report, we can take a vote on the waiving of the reading of the report.
You can read the report, we shall read any desire to hear it.
We shall read the report. Mr. Cobb. Oh, I'm sorry. Please begin.
Chairwoman Louise McMahon called the meeting to order at 5:35 p.m. on Wednesday, February 4th, 2009, in the Caucus Room, 3rd floor, Danbury City Hall, 155 Deerwood Avenue. Present was committee members Phil Curran and Paul Rotello. Also present were Laszlo Pinto, Deputy Corporation Counsel, David St. Hilaire, Finance Director, William Montgomery, President of the Land Trust of Danbury, and members of the public. Chairwoman McMahon explained the purpose of the evening's meeting was to review and consider approving the proposed property tax abatement for conservation organizations. Chairwoman McMahon asked Corporation Counsel Pinter to provide everyone with some background regarding the request before the committee. Attorney Pinter explained that there is a desire to have the Common Council adopt the provisions of an enabling act that provides immediate property tax relief to land trusts that receive tax bills for property they have purchased or received via donation. This is an enabling legislation, which means towns are authorized to immediately abate the property taxes owed by non-profit land conservation organizations should they wish to do so. Mr. Rotello asked why the land trust would pay such taxes. Mr. Montgomery explained that there are occasions when taxes are due after the closings of a transaction, whether it is a clerical error, an oversight, back taxes, etc. Mr. Curran asked where the trust funding comes from, and Mr. Montgomery explained through memberships, donations, and small grants. Mr. Curran asked Mr. Montgomery what action was being sought from the Common Council. Mr. Montgomery's response was for the Common Council to pass an ordinance that would stop tax payments as of the date of closing. Mr. Curran asked Mr. Pinter if there was a downside for the city. Corporation Counsel Pinter explained that the legislation in question is narrow and only applies to nonprofit land conservation organizations. He recommended that the Common Council review requests and make decisions on a case-by-case basis rather than adopting an ordinance. If an ordinance is adopted, then the Common Council would be establishing law, which would be more binding. Mr. Montgomery pointed out that the board reviews the request for donations of land. They would not accept donations of land with back taxes owed. A small piece of property, landlocked property, anything that does not have a conservation value will not be considered. There are a percentage of cases over the last 15 years whereby the land trust owes some taxes after the closing as a result of some sort of error oversight. Corporation Counsel Pinter pointed out that the legislation has been put into place to correct errors that become burdensome to nonprofit land conservation organizations by forgiving the debt that was not incurred by the organizations. A motion was made by Councilman Curran and seconded by Councilman Rotello that the committee recommends to the Common Council that they adopt a resolution abating that portion of property taxes for the Land Trust of Danbury for a period to be determined by the tax assessor. The motion carried unanimously. A motion to adjourn was made by Councilman Rotello and seconded by Councilman Curran. The motion carried unanimously at 6:26 p.m. Respectfully submitted, Louise McMahon, Chairman, Phil Curran, and Paul Rotello.
Thank you, Counsel. It's a pleasure, Counsel. Mr. Collins.
Your Honor, at this time I'd like to make a motion that we receive the report and adopt the recommendations of the ad hoc committee.
Second. Motion made and seconded by Councilman Egershot. Discussion. Mr. Levy?
Thank you, Your Honor, and thank you, Chairman Manis, for reading the report. It was when a committee meets at 5:30, some people are not out of work and they can't come to the meeting, and it gives an opportunity. I realize it's on the web, but it gives an opportunity for the public to understand what the meeting was as well. I do have a question that I want to know through the chair, exactly how much money are we forgiving here?
Mr. Pinter?
There's no money specified for this particular request. What you're doing is you're instituting a procedure to adopt a resolution if the situation comes before you. So you'd be approving the practice, the policy that this enabling legislation allows for. So there's no specific money being requested at this time.
If I may follow up on that, would that be the sky's the limit with all properties that may now or in the future be in the hands of a nonprofit organization?
Now, there's two restrictions on that, Mr. Levy. One is that it applies only to the Land Trust of Danbury. They're the petitioner, and they came in to ask for this. Secondly, the request, when presented for a specific amount, would be adjusted with the assessor making a determination of, according to the law, the requirement of how this adjustment is to be made. That amount, whatever that amount is, would be adjusted in accordance with the assessor's calculations.
And if I may continue, that almost seems a little open-ended. I don't quite understand what. Are we committing this for a one-time piece of property or multiple pieces of property for now until the resolution is changed?
You're committing it. It's not open-ended. What you're doing is you're committing it to one entity for any property that they own or any property that they will purchase for which an error has occurred where they're liable for taxes that they shouldn't pay. So when that situation comes along, we being the city, will determine what that liability is, waive that liability through a formal assessor's review in accordance with your approval of this proposal.
My understanding is that the law, aside from the enabling legislation you're referring to, allows, if there is any errors, that those can be corrected by the assessor as well, without any other approval.
There's another procedure for correction by the assessor for clerical errors. If you go back 3 years in time for the assessor to make clerical corrections. These adjustments for this particular purpose aren't necessarily clerical. They could be other than clerical. It could be legal, it could be other omissions. That's why the legislature presumably enacted this legislation to cover those areas.
Can these be retroactive? In other words, to encourage people with large tax indebtedness to, rather than paying the taxes, to donate them to the land trust?
It's not retroactive, it's forward-looking. So it's as of the assessment year of 10-108. And so anything that happens subsequent to that would be worked into the adjustment.
Thank you.
Thank you, Mr. Levy. Further discussion relating to this proposal? Mr. Simon.
Thank you, Your Honor. I didn't initially have any questions on this, but to follow up on something that Corporation Counsel stated. If I'm correct, there is organic legislation in place at the state level that allows a procedure to address problems with taxes in this type of situation, correct?
Yes.
Is there a process that legislation dictates the city is supposed to follow? And is that the process we're following here, or are we doing some sort of hybrid?
Yeah, that's a good question, and there is no process. It's unfortunately, or fortunately, depends how you look at it, it's a very brief piece of legislation, but it's very straightforward. It really allows you to adjust on the date of acquisition. If the Danbury Land Trust of Danbury somehow is on the hook for paying taxes that it shouldn't have paid from the previous owner through a closing error or some other situation like that, then you'd be adjusting that through a process that the council committee adopted, which would bring in the assessor to make their determination and review the propriety of the adjustment, how much the adjustment would be, and then that adjustment would be made according to statute.
If I follow up, I'm just a little confused though that does the legislation, and is he into the committee, sorry, two questions here, contemplate an ongoing process or the remedy of a single mistake? Or not mistake, but a single, let's say, whatever it might be, an error, miscalculation, or a legal question with regard to tax liability? Because I think Councilman Levy mentioned something about it. Is this prospective or retroactive? He said it's prospective. I read the report as it being for this one situation. So, if you could clarify that through the chair, please.
That's your hybrid. The choices, according to the statute, are that you can adopt this by ordinance, which would be a permanent piece of legislation, or you can adopt it on a case-by-case basis. Since there isn't any present existing case for which this is to be applied immediately, what the council did was institute the opportunity to provide this benefit when a case came along. So what you'd be authorizing is the assessor to work with the requesting agency, the Land Trust of Danbury, to make an adjustment when presented to it in accordance with that tax obligation.
Follow up, and this might be a question better for the chair. I'm just going to ask fellow council members direct questions, but through the, I mean, not for the chair of the committee, not the chair of the body here. If there's not, I thought there was a controversy before us that this committee was trying to address, and I don't have a problem with that. I'm a bit confused that this is a remedy for a possible problem in the future. Or is there an actual land transaction that occurred where there is a tax issue? We want to remedy that, and so this committee's report and us voting on it would be applied to this single act. I'm concerned about something being prospective by resolution as opposed to ordinance, and it being for one entity going forward in the future, forever.
Yeah, that's if the Land Trust of Danbury comes in with a specific proposal. If you adopt this measure, you will be approving that adjustment by the assessor. There is no specified proposal before you now. What you're doing is approving the application of this legislation to the Land Trust of Danbury. So if they come in with a proposal next week for a $400 adjustment, we would be able to, through the assessor's office, to calculate that and make the adjustment.
Mr. Sadi, Mr. Montgomery's here. Perhaps he might want to shed a little light on that. Mr. Montgomery, you want to shine the light of knowledge on us?
Maybe the lawyers are overworking this, as usual, right?
Mr. Montgomery is president of the Danbury Land Trust.
Bill Montgomery, president of Land Trust of Danbury, 19 Delano Drive. We are a nonprofit, tax-exempt organization, as most of you know. And all of you have probably been through real estate closings, and you know that the way it should work is the two attorneys should work out the prorate of taxes at the closing. That's the way it should work with us too. And sometimes that doesn't happen for one reason or another. The one case that I can think of, another nonprofit organization donated 17 acres to us. It was nice land, sizable piece of property. And essentially their attorney said to our attorney, we're giving you the land, you take care of the remaining taxes. You're all probably much more familiar than I am with the way the grand list works, and so you don't want me to try to stumble through how that might affect taxes after the date of closing. In July of 2007, the governor signed Public Act 7-170, which essentially said land conservation is a good thing for the state, and we don't really want to discourage private land trusts from entering into deals because they're going to get hung with taxes for whatever the remainder of the grand list period might be. So therefore, the Public Act gave municipalities the right to, as Mr. Pinner said, either by ordinance or on a case-by-case basis to exempt the land trust as of the date of closing. I went to my friendly councilwoman, Mrs. McMahon, and asked her to take this up. She brought it to the council, who appointed the ad hoc committee, and they met, and you've heard the report. There have been some questions about scope here, and
Mr. Montgomery, can you just one question, Mr. Sadi had? Is there a specific?
I'm sorry?
Is there a specific piece of land where this is an issue
No.
right now?
As I said, the legislation gave. Well, let me back up a minute. I went back 15 years. There have been 5 cases of where we've gotten stuck for some taxes, even though we're a tax-exempt organization. They range from $23 to $485, an average of $318. That might not be a lot to some organizations. It's a lot to us. But there is no case on the books now. Sorry I didn't address your specific question.
No, you addressed it. You did address it. So then, and thank you, Mr. Montgomery, but not to you, but through the chair again to Corporation Counsel. And yeah, I'm confused by some of the explanation. I'm confused by the motion, and we talk about on a case-by-case basis. We can do it by resolution. But this resolution, does that mean that case-by-case basis where we authorize by resolution the assessor to adjust these matters when they come up? And can that be for any entity that falls into the category that's covered by the statute? Or is this is just for the land trust?
It's just for the Land Trust of Danbury. They're the requesting entity. The council could have spread it far and wide, but the committee at least recommended just that particular agency. If the council has choices, the council, if it wishes, could certainly adopt the resolution at the time a specific case came in. But the way the committee recommends this is that you adopt if you will, a broader approval, so that if this happens and the Land Trust of Danbury comes in and says there was a mistake, we need to talk to the assessor about working out the adjustment so that we don't suffer the consequences, then if you adopt this measure, call it a measure, you will approve that case by case, again, one case at a time.
And if I may follow up, and Councilman Cheney just said this to me, the motion seems a little confusing. Would it make more sense then, the authorization here would be that the council pass a resolution authorizing the assessor pursuant to the public act cited by Mr. Montgomery to adjust, under the circumstances prescribed in the act, the taxes for the Danbury Land Trust going forward?
Yeah, again, you don't have to. The legislation is such, Tom, honestly, that it doesn't require you to do any particular thing. You have wide latitude on this. You can do an ordinance, you can do a resolution, or you can simply say, we'd like to do this, and come back with something.
No, I understand that, and I don't need to be combative here, but I'm talking about the motion and not the interpretation of the law. The motion seems, and somebody said to me, it's a little maybe ambiguously worded the way it is. It sounds like we're talking about a specific case of abating. It says here, abating that portion of the property tax for land trust for a period of time to be determined by the assessor. I think what we're really trying to do here is give the assessor the authority by resolution to utilize the public act as cited by Mr. Montgomery to address tax concerns that are raised that are within the parameters of the public act for the Danbury Land Trust.
That's correct.
Tom, that's a fair. There is some lack of clarity in the language in there. The language doesn't. It almost implies a certain case. What it meant to say was that you're really adjusting based on the date of acquisition and how that spread is made. That's what that language was intended to say. The word resolution really means, typically we think of resolution as a document that you adopt. The resolution could be simply a statement that you want to do this. So it's a language.
It's a language issue.
So just in terms of parliamentary procedure, so we're all clear, the motion on the floor was to adopt the report and language that the report encompasses. So I don't think we go back and really amend the motion made in the report, but perhaps the maker of the motion could clarify exactly what we're voting on to make sure we're all clear. Does that would seem appropriate? And so, Cabo made the motion here at the council meeting. Second amendment, Mr. Neguseth. So Mr. Cabo, perhaps you just want to rephrase your motion so it's a little clearer. I guess you could adopt the report as presented to enable the assessor to
Ron, this time I'd like to clarify my motion so that it states that the council will adopt the report as presented with the intent of enacting the state legislation that enables the land trust to apply for the tax abatement through the tax assessor's office.
It gets it done. It's a little bit.
Close enough.
That works.
I'm pretty sure I covered it.
And we'll have the clerk insert the statute, all the statute now.
Thank you. Thank you.
Attorney's been okay, Mr. Sal.
Yes, I am.
You all feeling good now? All right, good. Any other questions? With that, I'll try your minds on the motion. All those in favor of adopting the motion, please signify by saying aye. Aye. All opposed, signify by saying nay. Ayes have it, motion carries unanimously.